chairman and other chairmen here present. I am Brigadier General M.U. Wambai, representing the Chief of Army Staff. Please permit me to stand on the existing protocol. In respect of the first bill, which is the exclusive economic zone, the first speaker has mentioned that the bill is full of some typographical errors, which we have also observed, and when we submit our observations, I think it will be harmonized. For the second bill, which is the Firearms Act, I will go straight to Section 27, Sub 1C of the bill, that is of the Principal Act, which provides for a fine of 1,000 naira, which the bill seeks to increase to 1 million. However, Section 2 of the bill erroneously captured 100,000 naira. This should be corrected to reflect instead of the 1,000 naira. Section 5, subsection 1, the word county should also be corrected because it's supposed to be country. We still have section 7, sub 1, and the word a was used instead of us, and it would have conveys different meaning. Section 5, sub 3 of the bill makes the Office of the National Security Advisor as the central coordinating body for the illicit and illegal firearms confiscated or seized by any law enforcement agency. However, the bill does not define the law enforcement agencies. Instead, it mentioned the Armed Forces of Nigeria, AFN, MPF, Nigerian Police Force, and other officers of law enforcement agencies in Section 5, sub 1 of the bill. Though this may cause ambiguity, there is the need for the drafters to clearly define law enforcement agencies under Section 5 of the bill to include the Armed Forces of Nigeria, Nigerian Police Force, and other security envisaged under the bill. Section 5, sub 5 of the bill provides that firearms that are that are of military serviceable grades shall be deployed for military purposes. However, the bill is silent as to the fact that it is not all kinds of rifles or firearms the military deploys during operation. The bill uses mostly firearms listed under parts 1 and 2 of the schedules to the Firearms Act, Chapter F28, Laws of the Federation of Nigeria 2004, such as the artillery guns, bombs, rifles that use the 7.62 millimeter special ammunition, etc. Accordingly, it should be important for the said Section 5, sub 5 of the bill to clearly indicate that the firearms listed under parts 1 and 2 of the schedule of the Principal Act are of military serviceable grades. In the same vein, there is the need to provide or make proviso to Section 5, sub 5 of the bill that those firearms which though are serviceable but not of military grades or use shall be deployed to the Civilian Joint Task Force or immigration or civil defense, our registered vigilantes, because it is very, very important as these people are deployed in various areas to assist the military. In view of the foregoing, distinguished chairman of this committee, I think this when we submit our report, observations, it will be thank you very much.
Thank you so much. We'll follow with Nigerian Navy. Distinguished Senator Bamidele, the chairman of this session, the co-chairman, permit me to stand on existing protocols. I am Rear Admiral Adeseye Okeayobanjo, Director of Operations, Naval Headquarters, and I'm representing the Chief of the Naval Staff, Vice Admiral A.Z. Gambo, Admiralty Medal. The officers with me include Commodore J.S. Malafa, the Director Legal Services, and Commodore A.M. Umar, the Navy Liaison at the National Assembly. Let me express the appreciation of the Chief of the Naval Staff for inviting us to this public hearing. The Chief will have been here by himself, but as you will understand, other operational exigencies made it impossible for him to be here. And so I'm delighted and honored to be representing him. The issues of the day, we consider them very, very important. Public hearing on two important draft bills relating to the Nigerian Maritime Zone and then the Firearms Act. I'm glad that the representative of the Presidential Committee had spoken before my colleague from the Army and then my humble self now. I'm happy that some clarity has been explained already with respect to the bill that was submitted to the Naval Headquarters for consideration. And we do note some of those editorials that have been corrected and also some of the definitions that have been put in the right perspective. And so with respect to the repeal and amendment bill for the Nigerian Maritime Zone, the Nigerian Navy has 3 observations which have already been put in our submissions already. But for the purpose of the audience, I'll just go through them again. So with respect to the Nigerian Maritime Zone Bill, Section 8, Subsection 3 of it, provides that in the absence of the required distance to constitute an exclusive economic zone between Nigeria and our coastal neighbor, the zone shall, quote, shall not extend beyond the median line from the respective baselines of each country. It is important to state that while this provision is laudable, a neighboring country is not subjected to Nigerian municipal legislation. Thus, of the section cannot be enforceable against a neighboring coastal state. Accordingly, it is suggested that the section be amended to read, I quote, in the absence of an agreement, the delimitation of this zone as between Nigeria and any other coastal state shall be in accordance with Part 15, Roman numeral, of the United Nations Convention on Law of the Sea, unquote. This is in line with Article 74, subsection 2 of the United Nations Convention on Law of the Sea, which provides that if no agreement can be reached within a reasonable period of time, the states concerned shall resort to the procedures provided in Part 15, Roman numeral. The second observation is with respect to Section 12, subsection 4. It provides that the, quote, the arrested vessels and their crews shall be promptly released on their provisions of reasonable bond or other more acceptable security, unquote. It is pertinent to state that perpetrators of serious crimes such as piracy, sea robbery, or oil bunkering ought not to enjoy the benefits of freedom simply by posting bond, which could have been derived from proceeds of the said crime. This is because the option of bond could encourage rather than deter criminals. Notably, Article 73, subsection 2 of the UNCLOS provides for the prompt release of arrested sea-going vessels and crew upon the posting of reasonable bond, as well as notice to flag state on actions taken against the vessels. It will suffice to state that Article 73 of the UNCLOS deals with coastal state enforcement jurisdiction on the breach of its sovereign rights over the living resources in its exclusive economic zones. In other words, the article provides for coastal state enforcement of fishing regulations in the EEZ. Thus, Article 73, subsection 2, which requires release of vessels and crew on bond, is in respect of vessels arrested for breaching fishing regulations in the EEZ, and not a general requirement for vessels and crew arrested by a coastal state for other very serious offenses. Also, in furtherance to the provisions of the United Nations Convention on the Law of the Sea, the United Nations promulgated International Convention on Arrest of Ships, 1999. Article 2 of the Convention provides that, quote, arrest means any detention or restriction or removal of a ship by order of a court to secure a maritime claim, but does not include the seizure of a ship in execution or satisfaction of a judgment or other enforceable instruments, unquote. The definition of maritime claim under Article 1 of the Convention does not include criminal matters. Therefore, if a ship is arrested in connection with a criminal offense, it is excluded from the scope of the Convention. And so, gleaning from the references cited above, it is suggested that a proviso could be added to the proposed Section 12, subsection 4 of the Nigerian Maritime Zones Bill to read, and I quote, the provision for bond under this section shall, however, not apply in respect of persons or vessels arrested for criminal activities, and I put it here, such as piracy, sea robbery, and or illegal oil bunkering committed within the Nigerian maritime environment, unquote. The third observation is with respect to Section 24 of the bill. It defines minister to include the minister responsible, I quote, include the minister responsible for transport or any other minister of the Federal Republic whose mandate covers any of the provisions of this act, unquote. It suffices to state that Section 7, 12, 16, and 17 of the bill highlights enforcement of legislations and laws within Nigerian maritime zones. It is also tried to state that Section 1, subsection 4 of the Armed Forces Act specifically outlines the role of the Nigerian Navy, which include enforcement of national and international maritime laws within Nigerian maritime domain. It would therefore be more appropriate for the Minister of Justice to undertake the enforcement under the Nigerian Maritime Zones Bill. Accordingly, the definition of minister could be amended to read, I quote, the Minister of Justice or any minister of the Federal Republic of Nigeria whose mandate covers any of the provisions of this act or who is designated to act from time to time, either generally or in any specific case under this act, unquote. With respect to the Firearms Act Amendment Bill, we recognize that the bill seeks to amend the Firearms Act, Cap F28 Laws of the Federation of Nigeria 2004. Part of the things that we see that the bill seeks to do is to increase the imposed fines for offenses. Specifically, the bill seeks to amend some sections of the Act. The bill also provides for the deployment of seized illegally imported military serviceable grades to the armed forces of Nigeria and destruction of seized non-serviceable grade firearms or in possession of civilians without valid license. Ultimately, the bill is targeted at preventing the circulation of illegal firearms in our dear country, Nigeria. So the Nigerian Navy believes that the bill is important in view of the increase in proliferation of small arms in the country currently. Also, the proposed amendments are considered apt and commendable in the context. On the other hand, the observations and suggestions on the Exclusive Economic Zones Act Repeal and Enactment Bill are considered relevant. And so, in line of the foregoing, and as directed by the Chief of the Naval Staff, I want to respectfully request this distinguished committee to consider and amend the Nigerian Maritime Zones Act Bill in line with our observations. I want to say a big thank you on behalf of the Chief of the Naval Staff once again for giving the Nigerian Navy the opportunity to make these observations. Thank you very much.
Thank you so much. A lot of clapping has been going on here this morning, this afternoon.
Committee on Judiciary, Human Rights and Legal Matters, Navy and Marine Transport. Please permit me to respectfully observe the already established protocol. I am Air Commodore Oyabu. I am the Director of Armament, Nigerian Air Force, and I'm representing the Chief of the Air Staff, Air Marshal Oladayo Amao, Distinguished Flying Star. And this morning I shall be making inputs in today's public hearing on behalf of the Nigerian Air Force. I shall begin with the bill for an act to repeal the Exclusive Economic Zone Act E17 Laws of the Federation of Nigeria 2010 and Territorial Waters and Marine or Maritime Zone Act. Now, having gone through the proposed bill, the Nigerian Air Force is of the view that Section 7 and subsection 4 of the bill, that is on jurisdiction and penalty, should read, and I quote, "Any person found guilty of removing archaeological or historical objects from the seabed of the contiguous zone of Nigeria in violation of this act shall, on conviction, be liable to imprisonment for a term of not less than 2 years or a fine of not less than 2 million naira, unquote." Now, the Nigerian Air Force considers that a penalty of 500,000 naira as proposed in the bill is too lenient for the offense. And next, I shall quickly go to I'd like to say this, that my colleagues that have spoken ahead of me have actually captured some of the points that I would like to raise, so I'm not going to bore you with so much of these details because they are already contained in the memos that we're going to be submitting. So the next is on the input on the bill for an act to alter the Firearms Act, Caps F28, Laws of the Federation of Nigeria 2004. And the first observation is that Section 39 of the bill, that's subsection 1, made it lawful for officers of Nigerian Armed Forces, Nigerian Police Force, Nigerian Customs Service, Nigerian Security and Defense Corps, and officers of law enforcement agencies to seize and confiscate illegal firearms. But however, it is observed that this section 38 of the Parent Firearms Act provides that only members of the armed forces, the police, are excluded from the provisions of the Act in relation to firearms and ammunition issued for official purposes. This section 38 did not include other law enforcement agencies authorized to carry firearms, but in section 39 in this bill empowers these agencies to seize firearms. Accordingly, it is suggested that section 38 of the Parent Firearms Act be amended to include other security agencies authorized to bear arms and seize illegal ones. The next is section 39, subsection 2 of the bill provides that an agency responsible for a seizure shall record, among other things, the date of destruction and location of destruction. However, section 39, subsection 5 gives the National Security Advisor the duty to destroy unserviceable weapons after they have been submitted by the agency that seized the weapons. Now, the destruction is not done by the security agencies in question, and as such, there's no need for the agencies that seize the weapons to record the destruction and location of the same. It is thus suggested that the National Security Advisor records the dates of destruction and location of destruction. And the next one is paragraph 7, which introduced a new section 41 with the heading Offenses. But having gone through it, we observe that the provisions under the subsections under the section 41 are not related to offenses provided in section 40. So it is important to take note of this and so that it can be corrected appropriately. Furthermore, in the proposed bill, section 27, subsection 1 of the Principal Act was amended by substituting 100,000 naira with 100 million naira, or imprisonment of a term of 2 years or both. Nigerian Air Force considers the fine of 1 million naira as grossly inadequate for such offense, and accordingly, the Nigerian Air Force recommends the imposition of a stiffer penalty, such as the fine of 3 million naira or imprisonment of a term of 3 years or both for the offense. Now, section 28 of the Principal Act stipulates that the holder of any license or permit granted in accordance with the provisions of this Act shall produce the same, and if so required, any firearm or ammunition to which such license or permit relates, upon the request of a police officer, and in default shall be liable upon conviction to a fine of 100 naira or imprisonment of 6 months. Now, section 28 of the Principal Act was amended by substituting 100 naira with 100,000 naira. It is the considered opinion of the Nigerian Air Force that the sum of 100,000 naira fine proposed in the bill for breach of this section is in order and should be sustained. Next is section 35, subsection 1. We observe that the President, if he deems appropriate, may at any time, by proclamation, prohibit the possession of or dealing in any firearms, ammunition, either throughout the Federation or in any part thereof, and either absolutely or except such subject to such restrictions, conditions as may be specified. Meanwhile, section 35, subsection 2, stipulates that a proclamation under subsection 1 of this section may require the surrender of firearms and ammunition within a specified time and to a specified authority, and any person neglecting or making such surrender or being in possession or dealing in any firearm or ammunition during the period that such proclamation is enforced is guilty of an offense and is liable to a penalty of 1,000 naira or imprisonment for 2 years or both. Now, Section 35, subsection 2 of the Principal Act was amended by substituting 1,000 naira with 1 million naira. However, the Nigerian Air Force is of the view that a fine of 1 million naira being proposed for violating this section is inadequate. We therefore recommend imposition of a fine of 2 million naira in addition to 2 years imprisonment of breach of this section. This brings me to the end of my presentation this morning. I want to thank the Senate once again, the Senate Committee once again, for inviting the Nigerian Air Force to make this presentation. Thank you for your attention.
Welcome.
Thank you so much. We really appreciate that.